In nearly every real estate purchase contract out there, there are performance deadlines where the parties have agreed that by these certain deadlines, they will do something. Whether that is the seller conveying information to the buyer, information about the property, or it is the buyer agreeing to do certain things like apply for a loan or obtain finance. While those performance deadlines are set forth in the contract to signal to the parties the time frame that they have to fulfill those duties, questions arise as to what happens when a performance deadline is missed. That is, what happens if a party goes past the deadline without fulfilling the obligation. Now, there are good questions that arise when a party does not fulfill their obligations by the agreed upon deadline. And in this video, we are going to address one of the questions, which is, how does a missed deadline affect the remedies in the contract? So as always, guys, this video is for educational purposes only. And if you have a specific legal question regarding a situation that you're involved in or have a client involved, make sure that you seek legal advice in your area, because individual facts and nuances in the law could affect any legal analysis. All right, so the situation is we've got two parties in a real estate transaction. We've got the seller and the buyer, and they have agreed to move forward and acquire and sell the property. And along the way in that transaction, there are deadlines. And let's say, for simplicity's sake, that the seller has a deadline to convey certain information about the property, such as financials or defects about the property or recent remodels that they have done. And on the flip side, the buyer has deadlines to perform their due diligence, to do inspections about the property, to raise any concerns about the property for the seller to agree to repairs, and also deadlines for financing. That is, the buyer obtaining the financing or securing the financing to complete the sale. And let's say that as the transaction moves towards closing, the buyer doesn't apply for the loan by the finance deadline, therefore doesn't secure the financing by the finance deadline. And just to spice it up a little, let's say that the seller also misses their deadline of conveying information about the property, getting the buyer all the information about the financials or the defects and the information about the property's history. Seller just drops the ball on that too. And just to make things even spicier, let's say that both parties miss the closing deadline because the buyer hadn't secured their financing yet and the seller wasn't going to close because the buyer didn't have financing. So they just kind of go forward, as the days and the weeks go on, just kind of waiting for the buyer to give notice that we're clear to close, right? We got the money and we're going to go ahead and move forward. So deadlines have been missed all over, right? And let's say that the seller's a little bit upset that they haven't gone through closing. So the seller just cancels the deal, says, hey, we are way over the deadlines. I'm going to put the home back on the market. Buyer now has secured financing, sues the seller and says, let's go ahead and close, right? I want the court to compel them to close now because we got the financing. They didn't close back at the deadline, so they were waiting for me. We're ready to go. Let's move forward. So what do you think? Let's say you're the judge. How would you rule if this case was before you? Yeah, both parties missing their deadlines all over the place, but moving forward, as just kind of waiting for the buyer to get the financing, and now we're ready to close. Neither one have really canceled the contract. So how would you rule? Well, this is the exact set of facts that happened in a Colorado case that was ruled on in 1981. In that case, the seller missed their performance deadlines that they had agreed to in the contract, and the buyer missed their deadlines that they agreed to in the contract. And they both moved toward closing, and closing came and went with neither side closing on the deal. And when the buyer finally obtained the financing and was ready to close, the seller came back and said, well, now it's going to cost you more. We're going to raise the price because that old contract is done. We both didn't execute on the contract. We both didn't fulfill the terms. So we're going to have a new contract with a higher purchase price. Buyer sues the seller for performance, saying, we got the funds now. We have the contract. Honor the original terms. And the case went to trial. Let's take a look at what the trial court found in this case that triggered the appeal. So the Court of Appeals notes that the trial court found on supporting evidence that both sides wholly failed to perform their obligations under the contract. The vendors, that's the sellers, failed to furnish purchasers with evidence of good title and a warranty deed prior to or on May 30th, 1976, or give notice of the hour and place of closing. Purchasers failed to apply to the bank for permission to assume the first deed of trust, or apply to any lender for a loan to pay off the indebtedness prior to or on May 30th, 1976, or to tender the proceeds due under the contract to vendors at any time. The court concluded that there had been a bilateral breach of the agreement. As a result, purchasers were not entitled to specific performance, and vendors were not entitled to retain the earnest money as liquidated damages. So in this case, the buyers had contracted with the sellers to assume the seller's loan. And by the deadline, not only had they not satisfied that obligation, they hadn't even applied to the bank to assume the loan. And the sellers, in turn, they never issued the time and place of closing, which was part of the contract, nor had they handed over the warranty and fulfilled their closing obligation. And so the trial court finds that both sides have breached the agreement. And because both sides have breached the agreement, they have knocked each other out. And as a result of those knockout blows, there's no relief for any party. So naturally, there is an appeal because the buyer wants to get the property. On appeal, the court explains the law. It says the provision in the contract pertaining to the manner in which the purchase price is to be paid contains the implied promise of the purchaser to make reasonable efforts toward fulfilling its requirements. In the law, this is called the implied covenant of good faith. This implied promise is attached to every contract that you and I will ever enter into. That is to say, it's never needed to be in writing in the contract. It is there by law. The law says that when you and I get into a contract, we are both making an implicit promise recognized by law that we're going to do whatever we can. We're going to make reasonable efforts to fulfill our part of the agreement. And further in the law, in the event the vendor fails to perform under the contract, the purchaser is not excused from all efforts if he desires to preserve the right of specific performance. Court is explaining here that when you're in a contract and the other side breaches, and you now want to sue them to compel them to fulfill their obligations and do what they promised to do, you've still got to do your part. You still have to make those reasonable efforts to fulfill your obligations in the agreement if you want to preserve the right to sue the other side. So the court makes the logical conclusion. It says purchasers were not entitled to specific performance as they failed to tender payment as required by the contract, which provided that time was of the essence. Now, a little important piece there, time is of the essence. That is telling us that in the contract there was a provision that stated time is of the essence. And in the law, in contract law, a time is of the essence clause indicates that deadlines are important, right? Deadlines are hard and fast. They cannot be broken. If you do not fulfill your obligations by a deadline, you are in breach. So that's what happened in this particular contract in Nix v. Clary. There was a time is of the essence provision in the contract. And buyer didn't tender the payment by the deadline. They didn't assume the loan by the deadline. They couldn't perform by the deadline. Therefore, the buyer had breached the contract. And because the buyer was in breach, they had lost the right to sue the seller to get them to perform on the contract. As far as the seller goes, the court concludes that the vendors were not entitled to retain the earnest money as liquidated damages when they were themselves in default under the contract. And the judgment of the court directing return of the earnest money to purchasers was proper under the circumstances present here. Pretty self-explanatory, because the sellers had breached their part of the agreement and they did not convey a warranty deed, that is, they didn't go to closing and sign, and they didn't notify the buyer of the place and time of closing as was required in the contract. They were in breach too. They didn't do those things by the required deadlines in the agreement. Therefore, they had no right to retain the earnest money as liquidated damages. Remember, the buyer's earnest money is a potential remedy. So if the seller is going to retain that earnest money as liquidated damages in the event of a buyer breach, well, the seller has to perform their obligations in a timely manner. Otherwise, they're going to lose their remedies in the contract as well. All right, so does that make sense? Hopefully I explained the case well enough and you can see that deadlines in a contract are important. Not just because it is the set time for performance to happen, but because if they are missed, you could lose remedies in the contract. And that's a big key. That's a big factor in any contractual transaction in real estate. Make sure you meet your deadlines. Otherwise, when the other side breaches the contract, you might experience a double knockout in court. Hope you guys enjoyed the case. Leave a comment, let me know what you thought, and if you have a question of law that you would like to see broken down, drop that there too, and we'll see what we can do for you. And remember to like and share the videos with others so that they can learn the importance of contract deadlines and the possible ramifications if those deadlines aren't met. And as always, click subscribe so you get notifications when I drop the next video breaking down the next case.